Everyone, Dwayna Boswell O'Shell here with the Boswell Law Firm, and I am here with our Facebook Live for this week. And it's been a little bit of a crazy week here, so I'm sure it has been everywhere. People are getting ready for spring break, the major week next week, and even in the week after for some schools. So first, I just want to wish everyone a very, very happy spring break, and that everybody is safe. And just remember, we still have COVID out there, even though things are improving. So just continue to be vigilant and take care of yourselves. Excuse me. So it's been interesting how we seem to get different cases in, and when we start getting a different case in, the time we seem to get in batches. So this week we had a couple of different habeas corpus actions. Now, most of the time when you hear habeas corpus, it has to do with criminal law matters. Getting somebody released from jail that has been kept in the jail, and you're just trying to get them out based on some legal reason that they should be entitled to be released. So in family law, we also have a habeas corpus action, and that is when somebody is wrongfully withholding a child, either based on a court order. So you've gotten your paternity established, or you've gotten your suit affecting the parent-child, or even in a divorce action, you already have your possession access schedule established by a court order, and the other parent refuses to return. You can file a habeas corpus petition asking the court to order them to bring the child to the court on a certain date. And typically that date is fairly close to when the judge signs the habeas petition. So that is when that you can get the children returned when the other party is withholding. Now, if you have an immediate danger to a child from somebody that's withholding, and I will point out that it does not have to be a parent that is withholding. That a habeas can be used on any person that is withholding the child. Going along with a habeas is what we call a writ of attachment, and that requires an affidavit to be filed with the court, so the court can rule, and it's usually ex parte, so there's usually not a hearing beforehand, that they believe, based on the affidavit or maybe even testimony from someone, that there is an immediate danger to the child. Then they can issue a writ of attachment, which goes to a sheriff or constable, and the sheriff or constable goes in and removes the child from the home at the time that they serve the writ, and delivers the child either to the court or to a specified person in the writ. So those aren't easy to get. They have to have some extreme allegations to get one of those without a hearing. But habeas, there's a couple of different ways to establish your right under a habeas. One is, like I mentioned, a court order. So you would just want to attach a certified copy of that court order to the petition, file it with the court, and then the court can look at that and say, yes, this is the parent that should be in possession, and that is not the person in possession. Let's issue the habeas. Or if there isn't a court order, if you can establish that you are the biological parent of the child, then that would also entitle you to immediate possession if there is not a court order. Now, there are some defenses to the return of a child. It's difficult to defend against a writ of attachment, but those get you into court really, really fast. But even in a habeas, there's a few different defenses that you can bring. One of those is that the child has been voluntarily relinquished to you for over 6 months. So if you have a parent, they leave the child with you, and it's been more than 6 months, then that can be a defense to habeas and the immediate return of the child. Another defense is to say that there is a SAPSR pending, and you have temporary orders, and they're set at the same time as the habeas is set. Then they'll typically do the temporary orders hearing and get more information. The third defense is there's an immediate danger to the child. or returning the child to the other parent would put that child in danger. There's a lot of case law on different things that can constitute a danger, and so that is not always the easiest to prove, and you would have to show that it's something that if a child went back now would be an immediate danger. So that's the main ways that you can get a defense against a habeas. Otherwise, the court's going to look at who has a superior right to possession, and if one of those defenses don't fit the scenario, then they will order that the child be returned. Now, when you're served a writ of habeas, you're ordered to produce the child in court at the date and time of the hearing. So once we return back to in-person, and a lot of the courts are still doing the habeas via in-person hearings, then you would, if you receive the petition, you would have to physically bring the child to court, because the court's going to make a decision on who that child goes home with that day. And if they order that the child gets returned to the person that filed the petition, then the child would be leaving the courthouse that day with that person. Like I had said earlier, the difference with the writ of attachment is when they serve the paperwork, they immediately take the child then. Either bring it to the courthouse or to the person that filed the petition. So there's a lot more that goes into those, but that is a quick breakdown of a procedure that is available to any parent or person that has a court order out there to be able to get those kiddos back home as quickly as possible. As always, if you have any questions, you can always direct message me in Facebook, or you can send me an email at service@boswelltexaslaw.com, or you can give us a call at 832-919-6595, and we're happy to answer any questions. I hope everyone has a beautiful weekend and that everybody stays healthy and safe. We'll talk to you next week.